experience with these high dollar cases is that they take more time and resources. They're often very document intensive. There are often multiple parties and multiple counsel involved. These are people who are disputing their attorney's fees. So in this approach, the highest increase will be borne by those with the highest dollar disputes. Now, I do also want to note that for those folks who can't afford the fees, regardless of the amount in dispute, there is a fee waiver application available, and fees can be waived wholly or in part. And I also want to note that the fees for this program have not increased in well over 15 years. So we are asking the board to adopt the proposal today to increase the fees, and I'm happy to answer any questions.
Thank you, Ms. Lawrence, and it seems like this is a continuation of the 2023 state auditor's recommendation that we examine, like you said, the fees where there's a significant structural deficit. And so I think this is us being responsive to the state auditor and their very real concerns that we address structural deficits in whatever way we can, and that the fee arbitration program was not arbitrarily singled out, but this has been a department-wide look. Is that correct?
That's correct. Yeah.
All right, thank you. Any questions, Trustee Huser?
Has something been done to address the cost side of things because a $700,000 structural deficit seems like a lot? So we looked at that side as well.
Well, the costs mainly are labor costs, to be honest with you. We do have a relatively small team, but most of it is labor costs that you're seeing, and they rose significantly from 2022 to the present. So as I mentioned, we certainly have tried to bring some efficiencies to the program, and I think we've done what we can there. But other than that, you know, this is really the only way that we've tried to manage it.
All right, yeah, thank you. Yes, Trustee Barahona.
Thank you, Mrs. Lawrence. One sort of thought I had is future increases and how we can get a cadence to consider this every other year, perhaps, because of the 15-year gap. I think that to close the structural deficit, we're going to have to think about this more long term. And so I'd like to propose that this is assessed, you know, you would be best here in terms of your recommendation, but every other year, or every 2 years, or every 3 years, just so that we can keep up and be really clear and upfront and transparent with folks of how we anticipate closing the structural deficit over time, and also, you know, make those considerations. But I'm curious if that's something you're thinking about already, or something that we can consider going forward.
I'll answer that because the Finance Committee did direct staff. We previously had in place a policy by which fees would be assessed every 5 years. That policy was only adopted in 2017, which is why you've had 15 and sometimes 25 years of not reviewing fees. But last year, I believe it was last year, the Finance Committee directed acceleration of that, and I believe we settled on 3 years. And in addition, annual adjustment by a CPI or a COLA of all of our what we call service fees. So I think that sort of instinct that you have has been addressed by previously adopted policy of the Finance Committee.
Got it. Predates my current Finance Committee time, so I appreciate it. Thank you so much.
All right, we're digging back into the History Channel on some of this stuff. All right, any other questions, comments? Yes, Trustee Tony.
I support this proposal. I have a question on mechanics. So what I'm more familiar with is, you know, that a, you know, client and attorney, they, you know, reach an agreement as to what the fee is going to be. And a lot of times it's based on percentage of, you know, getting an outcome. So I'm going to give 30% as an example. I'm not saying that's, you know, but let's say that the attorney fee is, uh, you know, you know, I guess what I'm trying to figure out here is, and, okay, no. Okay, this is a dispute between a client and attorney for how much they were charged, right? How many hours, the amount, stuff like that.
Yes, I mean, there's generally a dispute over, not that some amount be
Right,
paid,
right.
but what amount is going to be paid.
Okay, so my question is, this percentage, where does it come from? Does it come from the client? Does it come from the attorney? Is it split in half? What's I'm just trying to understand the mechanics. I don't know how this stuff works.
Right. So when someone actually applies for the program, they indicate how much the attorney has charged them, how much the attorney says they owe, how much they've paid, and then also how much they think they owe, essentially. And whatever that is, then is the disputed amount. So it could be $10,000, could be $100,000. And whatever that the disputed amount then is what the percentage is based upon. And it is paid by the party seeking the arbitration. 99.9% of the time, that's the client.
All right, this is essentially approving the raising of the fees. This is not putting it out for public comment, but actually approving the increase. Can I have a first and a second?
Stevens, so moved.
Okay, first by trustee Stevens.
Second by Shelby.
All right, second by trustee Shelby, thank you. If there's no further discussion, may I have a roll call vote?
Barahona,
Aye.
Buenaventura,
Aye.
Chen, not present. Cisneros,
Aye.
Good. Trustee Good, I believe, stepped away. Grande,
Aye.
Huser, Shelby,
Aye.
Stevens,
Aye.
Sowell,
Aye.
Tony,
Aye.
Trejo, not present. Stallings.
Aye.
It's 10 ayes, 0 nays, motion carries.
All right, thank you.
Thank you.
And thank you, Ms. Lawrence, for your work on this. All right, this concludes the Regulation and Discipline Committee meeting. And we will go to our consent calendar, which is item 4. Give everybody a chance to reorient. And I'll put out a call to see if any trustee wishes to have any item removed from the consent agenda. All right, seeing none, I may have a motion.
I motion to approve the consent.
Just a quick question.
Okay, I think we
Mr.
may have a question first. Trustee Sowell.
Chair Stallings, in the executive committee, you mentioned that you might want to have an item. Was it you said you might want to have an item pulled so Trustee Barahona could make a comment?
Yes, thank you for flagging that. I did reach out to Trustee Barahona about whether she wished to address anything in the appointments, the appointment liaison piece. And I don't think that that they did wish to add anything, but I'll open it back up to Trustee Barahona.
No, I think I'm great. I think, we appreciate the candidates and the decision and recommendation that we put forth. So thank you so much for circling back.
Absolutely.
I guess I'm maybe seconding.
I think, yes, we had trustee, was it Buenaventura? Who made the first? Okay, then a second by trustee Sewell. No further discussion. May I have a roll call vote?
Barahona,
Aye.
Buenaventura,
Aye.
Chen, not present. Cisneros,
Aye.
Good, not present. Grande,
Aye.
Huser, Shelby,
Aye.
Stevens,
Aye.
Sowell,
Aye.
Tony,
Aye.
Trejo, not present. Stallings.
Aye.
It's 10 ayes, 0 nays. Motion carries.
All right, thank you. So that concludes our consent calendar. As previously announced, we are going to be going into closed session, and I would anticipate that we'll, just for members of the board, that we'll come back into closed session at about 12:30, give you a chance to grab some food, and then we'll plan on working through lunch through the conclusion of the closed calendar. And we're going into closed session pursuant to Government Code Section 11126, sub E, sub 2, sub B, sub I, 11126, sub C, sub 1, 11126, sub C, sub 17, Business and Professions Code, Section 6026.7, sub C, sub 3, 6026.7, 6086.1, sub C, and pursuant to those previously mentioned code sections, we'll be going into closed session. And do we have an estimate on, if we get started about 12:30, on what time to expect to come out of closed?
I think 2 or 2:30.
Okay. All right, so the members of the public will hopefully be coming out of closed around 2 to 2:30, but depends on the items discussed. All right, so we will move into closed session at this point, and then trustees who are appearing remotely, you should have a unique link sent to you for that closed session. So we'll see you in a couple minutes. All right. We're now recording, and we're coming out of closed session. We're returning to open session, and there are no reportable actions to announce. We'll start back up with items under our business category, specifically 6.1. This is update on and approval of 2024 legislative priorities and affirmative legislative proposals and position on pending litigation. Joining us are Donna Hershkowitz and Bridget Gramme. Welcome.
Thank you, Mr. Chair, members. I'll just make a quick correction. That's position on pending legislation.
What did I say?
Litigation. Different people. Louisa, if you can put up the slide deck. As you heard from the title, today we want to quickly provide you an update on one of your approved affirmative legislative proposals, specifically that to earmark legal services funding for summer fellowships. Want to recommend a support position on SB 40 by Senator Umberg regarding certification of alternative dispute resolution firms, providers, and practitioners. Want to largely conclude with a discussion of the fee increase that's authorized in Assembly Bill 3279. Open it up for a discussion on the State Bar's position. And then we'll conclude with just a quick update on other affirmative legislative proposals that we are still in conversation with, approved affirmative proposals. We're still in conversation with legislative staff, just to let you know the status of those. I hope to be fairly quick this afternoon.
So I'll take this first one. As you may recall, the board already approved an affirmative proposal to extend the sunset date on the approval of allowing $5 out of the $45 that licensees pay to support legal services. It's voluntary opt-out fees to earmark $5 for summer fellowships at IOLTA-funded organizations. The board approved an affirmative proposal to extend that sunset date for an additional 5 years, and that proposal is currently in the fee bill right now. Right now, we're asking the board to additionally approve a proposal to increase that amount to $10 instead of $5 to support the fellowships. They've been a very successful endeavor. This proposal is supported by legal aid organizations, California Access to Justice Commission, and change lawyers. And given the high interest rates right now, this would not negatively impact other funding to other IOLTA organizations.
The second item that we want to turn to today is pending legislation. And this is Senate Bill 940 by Senator Umberg. And we are recommending that the bar take a support position on this bill. Senate Bill 940, among other items contained in the bill, would require the state bar to create a voluntary certification program for alternative dispute resolution firms, providers, and practitioners. That's a bit of a lengthy word salad, so going forward, I'll just say ADR providers. As a legislative analysis of SB 940 noted, the goal of the proposed state bar certification is to let those who are seeking arbitration or other dispute resolution services know which providers adhere to the highest standards of conduct in order to give the public faith in the fairness of arbitration services. The bill sets out minimum criteria for certification and then says, and any other certification criteria that are set by the bar. At the state bar's suggestion, the legislation would direct the state bar to create levels or tiers of certification, such as gold, silver, bronze certification, or whichever levels or tiers that we would come up with. This is modeled after the state bar's DEI Leadership Seal program. The higher level of certification would be reserved for those ADR providers who satisfy criteria that demonstrate that they have demonstrating their increased focus on consumer protection. We envision that the legislation doesn't require it, but we envision perhaps a working group that would help us develop the criteria for establishing what would qualify an ADR provider for those various tiers. Importantly, very importantly, recognizing the bar's precarious fiscal condition, Senator Umberg makes clear in the bill that the bar can assess reasonable costs on ADR providers who are certified for the program, and specifically has language that allows the bar to ensure that those costs would allow us to recoup startup costs for the development of the program, including things such as staffing before the program gets up and running, automation before the program gets up and running, sort of whatever startup costs that we would need in order to create the program, we can build that into the cost that we would assess on ADR providers in order to create this certification program that would be, again, a voluntary program for ADR providers. I wanted, because the rest of what we're going to go into is so different. I want to take an opportunity to stop right here and ask for questions.
What would motivate an ADR firm to pay money to get certification?
Great question. The thinking is that that consumers might be more likely to use an ADR provider that is certified by the State Bar, and one that is gold certified as opposed to silver certified. If gold certified means that they have demonstrated that their complaint procedures, for example, meet a certain level. If a gold standard means that all of their ADR providers have taken certain kinds of training, have X number of years of experience, right, whatever those criteria are that we develop, if it gives the consumer confidence that this is an experienced ADR provider, that might be why that they might be more likely. That was the intention behind the proposal. When you listen to Senator Umberg talk about it, he talks about Girardi, actually, and the sort of wanting to make sure that the public is protected and creating ways to ensure that the public is protected from those out there that are that may be willing to do harm, and that there just isn't enough information out there about ADR providers, and that's why he put in legislation that he wanted the State Bar to certify these programs.
If I could follow up, what's the level of interest that's been expressed by ADR firms when you've done little, just checking with them?
So we haven't done a lot of affirmative checking with the ADR firms. I know I've looked at the because we didn't propose this idea, right? It came from the senator. We certainly have taken a look at the analyses of this legislation as it has moved through the system, and the California Dispute Resolution Committee Council was opposed to the legislation, and so there have been ADR providers that have been opposed, because one of the comments that I noticed from CDRC was a concern that, as originally written, the certification would create a sense of a particular ADR provider being more experienced, being better, when there was nothing in the certification process that would establish them as being better or more experienced. And potentially that could be built into the process now. So essentially it was creating a certification process that people were going to be forced into in order to compete with those who maybe didn't have the same credentials, the same experience, but had the credential now of being certified. But by creating a program that allows the State Bar to come up with the criteria and come up with the standards, we are now creating something that really, we are given the opportunity to create something that would give some greater comfort that we are able to establish sort of levels of whether it's sort of experience or, again, sort of ensuring higher consumer protection for these firms based on their the level of certification that they qualify for.
Just a couple of comments on this. I think a State Bar certification for an alternative dispute resolution provider would be incredibly valuable, and they would find it to be incredibly valuable. That said, it can't be one-sided, like on consumer protection versus against business or whatever, because it's a joint selection, and so nobody would ever choose them. So it has to be neutrality based on some sort of criteria of experience and that sort of thing. But I think it would be something that would be very valuable, and that ADR providers, if we were to do it, would be, would be interested in it.
Two quick questions. The doubling of the amount going to, for the summer fellowship program, how much money do we think that this is actually going to be total that will be going to summer?
It's probably roughly about, so my math is pre-increase, but it was about 800,000 at $5, so 1.6 at 10.
Okay, all right. My other question is, this is probably more of a technical observation, Donna, and it has to do with the Umberg bill. Since I've been on this board, I'm not aware, or it's probably been very rare, except for the homeless program, that there's ever been a program or a policy that affects the state bar that's been done outside the fee bill. And I'm just interested in how that happened with this particular piece of legislation.
So it is fairly rare. As a matter of fact, this year, one of the board's affirmative proposals dealing with applying the enforcement mechanisms from the Political Reform Act to the bar is also in a bill outside of the fee bill. It's a state bar-sponsored bill outside of the fee bill. The legislative staff is very protective of the fee, of the state bar issues, and they tend to shepherd those issues into the fee bill. There have been issues periodically that show up outside of the fee bill. And this was one. I think part of it is this is one component of a bill that contains other bigger non-state bar related issues about arbitration in particular.
All right, looking to the screen, I don't see anybody with raised hands. Anybody else here in the room? All right.
Okay. The clicker is not agreeing with me. There we go. I think Louisa did it. She's going to make me feel like I did it. She did it. So the last big item that we wanted to open for discussion today is the board's position on AB 3279, specifically the amount of the fee increase that is included in that bill. This slide and the next one present a visual recap of the fee increase request, which you'll see on the left side as the state bar need, which is the amount that is currently supported by the board. And then on the right side, the amount that is currently authorized in AB 3279. So this slide that is up now is the request, as we've named it in the past, request to keep the lights on or maintain public protection. You'll note that the bill authorizes $77 of the requested $95. Staff's perspective is that the fee increase that's authorized by AB 3279 is a significant step forward toward meeting our 2025 expenses. Although we advocated strongly for the importance of staying at an 8% vacancy rate and not increasing it, we certainly understand the legislature's perspective and are looking for solutions that would enable us to continue to protect the public despite losing an additional 45 to 50 staff, which is what would result from having to grow to a 15% vacancy rate by April 2027, which is what is set forth in the bill. Now, the key to how we would be able to continue to protect the public with that additional, with doubling our vacancy rate, is investment in IT, information technology, infrastructure, and modernization. And so to that end, we have been advocating for the ability to use a portion of client security fund reserves as well as a portion of future client security fund collections for the State Bar's general fund. We've also been working on a package of collections-related initiatives that Bridget will mention in a couple of slides, and you'll hear a little bit more about from Araceli and Leah, I believe, in 2 agenda items from now. But these are the sort of key elements of the maintaining public protection need that we had identified for as part of our fee request. Let's see if this works now. Luis, I'm going to need your help to move to the next slide. And then this slide highlights the proposed initiatives that we set forth to improve public protection, and includes on the right side those which the legislation currently supports, and those for which there is not funding that has been authorized by the legislature at this point. You'll see specifically the 2 programs, the 2 initiatives for which funding has been provided to support our initiatives to improve public protection, the diversion program and the client trust account protection program, specifically adding compliance reviews and audits for the client trust account protection program. Next slide, please. So at this point, we wanted to tee up for the board several options for discussions for the next steps for the fee bill. The question is, what kind of position do we want to take? We currently have a position to support the bill if funded at the $125 level of increasing the amount of the fee. Obviously, the board can maintain that current position. The board might choose for full funding choose to support the bill if there was full funding for all of the elements of maintaining public protection, right? That full $95. Funding, if there was funding that eliminated the need to increase the vacancy rate, or support the bill if there's authorization, support the bill with the authorization to use a portion of CSF reserves and future CSF collection revenues for IT investment and modernization to face a future with fewer staff. So that's sort of, as I said, sort of understanding that with the amount of funding that is currently authorized in the bill, the $88 increase, and the ability to access a portion of CSF reserves and a portion of future CSF collections, we would be able to invest in IT infrastructure and IT modernization such that we would be able to face that future having fewer staff due to the increased vacancy rate. So we really wanted to put out there for the board to begin a discussion of where are we going from here, right? We've got the bill now, it's out of all of the policy committees, it's on the Senate floor, and with all goes well, we'll be heading to the governor at the end of August, and this is an opportunity to take a final evaluation of the position the board has taken and identify the direction to go in.
All right. Thank you for that, Donna. I think it really lays out the position that we're in, both from a financial standpoint as well as what's been discussed at the legislative level, and then what we as a board can do to further these objectives. So anybody want to weigh in? Does anybody have any questions? Yes, Trustee Sewell.
I first just want to appreciate the work of the staff as well as members of the board in working the legislature. I was vociferously you know, pretty miffed at one of our last board meetings because, you know, the funding level for the fee increase was at $65, I believe it was, and it has now jumped up to 88, and so I'm feeling it's still not you know, what we had originally asked for, which was the 125, but it has moved substantially in the right direction. I am now just a little miffed at why a year ago it was okay for us to use reserves out of the client security fund, and now we can't. And so I would, I think at this particular point, advocate for a support position with, you know, an amendment or an effort to try to secure the release of us being able to use the reserves in the client security fund for IT purposes.
Thank you for that. Looking over at the screen, any questions, comments? Here in the room, okay, Trustee Tony?
I think that what I would advocate that we do is to authorize the staff in consultation with the chair the ability to continue to negotiate the outcome that gets us closest to what we need. And I would keep it, I like Trustee Sowell's suggestion. I wouldn't want to limit it to just that. The process, the bill process often has fits and starts and will often have things that change at the last minute. And I would rather that we authorize people to make the negotiations and not have to come back to the board, because you can't when the amendments come out the day before the committee vote. Okay, and that happens all the time. So, like Trustee Sowell, I believe we're going in the right direction, very visibly, okay? And that we want the staff to feel that they have the authority to negotiate the best deal they can possibly get.
All right, thank you for that. And go over to Trustee Stevens.
I would echo. I'm not sure what that's about. Can you guys hear me okay?
Yes.
Okay. What's a question and then comment? What is the justification for denying the increase related to the lease? I mean, that's a hard number. It's not a programmatic issue. It's not discretionary. So what's the explanation on that?
Who wants to take that?
I think it's simply because they think the lease costs are too high, but there was a rationale. It was something like we weren't taking into account some savings that they thought they had identified.
Yeah, so the best that I can explain it is we were sort of building the budget from the ground up, right? We were saying, here's our budget, here's the amount that, here's the deficit, right? There's $20 million that we are short. They looked at the budget the other way. They said, here's how much you had last year. You paid this much toward building expenses last year. You're paying this much toward rent this year. So there shouldn't be a difference of $21. There should only be a difference of $15, right? Like it was looking at the budget from the ground up versus from sort of the top down, and they don't make sense. You can't reconcile them that way. They're different budgets. We have different expenses this year than we had last year, and I think that really was the difference. And so looking at it the way they were comparing, well, what happened to the rental income that, last year you had rental income, it should have gone here. Well, we're telling you what the what the revenue is, we're telling you what the expenses are, here's how it nets out. And so they were looking at the budget from a different perspective, and that's where we ended up. And we weren't able to get any closer than that as a result.
I mean, so, well, I mean, what I'm hearing from that is they weren't doing math. I mean, they weren't dealing in real numbers. And is there any room for us to go back and say, this is a hard cost? This isn't, there's not wiggle room. This is a number. And it just doesn't make sense to me that we wouldn't get that or stick hard to that line, because it forces us into a deficit position. We will run a deficit, and it's their doing. And then next year they'll say, what are you guys over there at the State Bar doing? You're running a deficit. And I, for one, don't want to hear that.
So I do think there are, I mean, one, I think they would say, well, no, we're the ones who don't understand the math. So I certainly wouldn't characterize it that way. I mean, I think the problem is that there are several issues. We know where, for example, we know that there's an escalation cost on the lease, and that the cost in 2026 is going to be 3% higher than it's going to be in 2025. We know that there's a higher cost for merit increases in 2025, in 2026 than there is in 2025. That's why we asked for an inflationary adjustment on some of these. And so we do know that there are going to be higher expenses in 2026, in 2027, than we are getting funding for in this fee bill. And so that's why we are looking to do investments in IT, and we are looking to do some things to adjust not only for the fact that we're going to have fewer staff, but that we know that there are some numbers that don't add up, frankly, and that we're going to have to adjust for this going forward. We haven't been successful. We have tried to have that discussion about the lease costs, and we haven't been successful to date. Certainly not something, there's no reason, nothing that says that we can't try and have that discussion again, but we haven't been successful to date.
All right, thank you for the question and the response. Any other questions, comments? I would just say, as someone who talks to the legislature, or who I've talked to quite a few of them in this past legislative cycle, and I testified at 2 different hearings. Trustee Tony's proposal, providing for some flexibility, would be welcome. At the last hearing, we took a position where we would support, if amended, to add, and the primary thing was the use of the reserves. And so having some additional flexibility, I think, would allow these communications to continue. And that's my hope, that we'll continue to work with the legislature to fund the needs that every single person in this room, I think, understands. So I would welcome that resolution if someone were to make that.
Louisa, can you put the slides back up? There's one more slide.
Oh.
Just so before you would do the resolution, I just wanted to highlight some of these outstanding issues that the board has already approved, that we are negotiating right now, and we're hoping will make it into the bill, but are not in it right now. So as Donna mentioned, I think you'll be getting more information about this. And the board has already approved seeking amendments that will allow us to enhance our collections activity. So for example, we're able to do an offer and compromise, or at least settle on discipline costs, but not on CSF reimbursement. So we're seeking to add parallel language to the CSF statute to enable us to work with attorneys who owe money to the CSF. And then working on where, how we can, where we can put that money when we collect it. We're also working on modernizing the lawyer referral service certification program we've talked about before, including the fees, consistent with the state auditor's recommendation that the fees match what the costs are for certifying that program. The use of Justice Gap Fund and legal services donations for urgent or emerging issues. Right now, those funds are distributed by the IOLTA formula, and we're trying to have a little bit more flexibility for, disaster relief, for example, to use those funds. The Client Trust Account Protection Program, we've been working for a number of years, as you know, about enhancing bank reporting. We're still working on that issue. The timing of bar exam evaluation studies, we're supposed to produce a report every 7 years on those. And in light of all of the things that are happening with the bar exam, we're just asking for an extension of time for those studies. And then a number of just technical amendments, nothing real substantive there. So those are all in the works and things that we're working with staff on now.
And so we have, there were two resolutions in the agenda item itself that dealt with the earmark of the $10 for the legal services funding for the summer fellowships and the support for SB 940. And then we were, following the conversation, going to put up separately a resolution about what you wanted to do on the taking a position on AB 3279. So maybe if we could take first the two that are in the resolution, that are in the staff report, and then we could do the other one after that.
And before we get to that resolution, any questions for staff on the items that Bridget just talked about? Okay, seeing none. The resolution is up on your screen. After you've had a chance to review, if I could have a first and a second.
I'll move the resolutions.
So I have a first by trustee Swell. Do I have a second?
I'll second.
All right, I'll give the tie to Sarah. So second by trustee Good. Unless there's any further discussion, can I have a roll call vote?
Barahona.
Aye.
Buenaventura. Trustee Buenaventura, are you present? Okay. We may have stepped away. Trustee Chen?
Aye.
Cisneros?
Aye.
Good?
Aye.
Grande?
Aye.
Huser?
Aye.
Shelby? Trustee Shelby is not present. Stevens?
Aye.
Soel?
Aye.
Tony?
Aye.
Trejo, not present. Stallings?
Aye.
It's 10 ayes, 0 nays. Motion carries.
And then Louisa, from the slate of alternative additional resolutions that I gave you, if you could put up option B. And then we're going to have to add something to it based on the conversation. So what this says is resolve that the Board of Trustees adopts a support position on AB 3279 and directs staff to advocate for inclusion of statutory language authorizing the State Bar to access a portion of CSF reserves and future CSF collection revenue for IT investments to adapt to a future with fewer staff. I think what I heard is to add a tail on that and authorize the staff to negotiate with the legislature. And here's where I'm not sure of the best words here, as appropriate to get to the best outcome. I was hearing different phrases from all of you.
I think you're adopting a support position, or I think if we go with Trustee Tony's approach, the Board of Trustees delegates to the chair the ability to establish the official position between now and the termination of the 25 legislative cycle, or whatever it is. I don't know, Trustee Tony, if you were going that far.
I guess what if this is just about the CSF reserves, we can vote on it like it is. But I was under the impression that part of this discussion was to authorize the staff and chair to be able to, negotiate the best, for a fee increase that, fulfills, best outcome for a fee increase. I don't know how to say it. So that, and then to leave the question of the support if amended, because we're in that thing up to, if something closes a deal, you get to close a deal. You don't have to come back to close a deal. So I'm not sure if this was meant to be restrictive only about CSF reserves, or if this was on the whole bill itself. That's what I didn't understand, and I was only suggesting this is fine, but I want there to be flexibility.
Yes, so we can change then the front part to resolved that the Board of Trustees authorizes the chair, or authorizes staff in consultation with the chair.
Yeah.
To negotiate to continue to negotiate the amount of the fee increase with the legislature, and then
And any other amendments needed to support the goals of the state bar.
Including adopting, something like that.
yeah, I think you could just go straight to the and directs, right? Take out the adopts a support position.
Yeah. Yeah.
Right, so we're crystal clear that you all want us to do that.
Yeah. I would change then the title of it, so that right now the title makes it sound like it's very specific.
Yes, that was just so I could track which one of these options you were.
I don't think we technically need a title at
No.
all.
Oh, we
We
don't,
would
okay,
just-
we're not
no.
voting on a title.
No.
Got it. Okay.
Could I also maybe just add that we take out that last to adapt to a future with fewer staff and just have a period after investments?
Yes. I like that.
All right, so, Trustee Tony, is this your resolution?
I'll make the motion. Thank you.
All right, thank you. Is there a second?
I'll second.
Okay, second.
I
Second by-
do just have one quick question. Donna, are we going to have a LEDS liaison meeting, do you think, before they come back into session, or once they get back?
Whatever you want.
Yeah, I think if everybody's schedules allow, then that'd absolutely be good.
We should, because we are trying during this interim period to advance the whole CSF IT issue.
So keep your calendars open. Okay, we have a second by trustee Sewell. Unless there's any further discussion, I'm gonna have a roll call vote.
Barahona,
Aye.
Buenaventura. I believe he stepped away. Chen,
Aye.
Cisneros,
Aye.
Good,
Aye.
Grande,
Aye.
Huser, Shelby, not present. Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo, not present. Stallings.
Aye.
10 ayes, 0 nays, motion carries.
All right. Thank you. Thank you, Donna. Thank you, Bridget. Item 6.2 is update on contracting with Kaplan North America LLC for preparation of California bar examination materials and consideration of actions, including contracts approval. This is being presented by Bridget Gramme and Program Director Audrey Ching. Hello again.
Thank you. There's Audrey. Okay, so you have this in your item already, but just as a recap of where we are. At the May meeting, we had planned and had on the agenda for the board to consider a contract with Kaplan to develop questions for the bar exam that would, in effect, replace the multi-state bar examination on the multiple choice section of the exam and allow the bar to administer the bar exam in a way that is more cost-effective and in allowing us to do remote and test center administration. It's also a way that the applicants have stated in multiple surveys that they prefer. On the day of the meeting, we received word from Kaplan that they wanted to withdraw their offer at the moment because they had received a letter from the NCBE, National Committee of Bar Examiners, raising potential copyright considerations and concerns regarding Kaplan's drafting of the multiple choice questions. In the last couple of months, we have been negotiating still with Kaplan and trying to address these particular concerns on copyright. And I'm happy to be recommending today that the board delegate the authority to the executive director and to the chair to finalize and enter into this agreement. We believe that the copyright concerns have been addressed, and I will just briefly highlight some of the key terms of the agreement that we're proposing, and then Audrey and I are here to answer any questions that you have. So the main key terms is that Kaplan would exit the retail bar prep business in California for the California bar exam. They would deliver us multiple choice questions that would be developed in time to administer for the February 2025 exam. There would be a 5-year term on the contract for a total of $8.25 million over the term of the agreement. They would provide both written questions for 2025, and then they will also provide essay and performance test questions beginning in 2026. They will also be providing applicant study guide and faculty guides at no cost, but in the late fall of 2024. And the State Bar will own the intellectual property of the questions. So those are the main terms that we have been negotiating on. And I just wanted to open it up and see if anyone else has any comments.
All right. Any questions or comments? Checking on the screen, I do not see anything. Here in the room, also seeing no hands. All right. Lisa, can we put up the resolution? All right, after trustees have had a chance to review the resolution, may I have a motion and a second?
So moved.
Second.
All right, first by trustee Barahona, second by trustee Grande. Unless there's any further discussion, may I have a roll call vote?
Barahona,
Aye.
Buenaventura, not present. Chen,
Abstain.
Cisneros,
Aye.
Good,
Abstain.
Grande,
Aye.
Huser,
Nay.
Shelby, not present. Stevens,
Aye.
Soel,
I'm a no.
Tony,
Aye.
Trejo, not present. Stallings.
Aye.
6 ayes, 2 nays, motion carries.
All right. Well, I think this marks a very important step in the state bar and our ability to have freedom in this area and the ability to develop our own set of questions. And I think it's certainly, if you read the media, you know that there's a lot of I think a lot of positivity about this, and I really look forward to continuing to work with Kaplan to fulfill this this agreement and to make sure that those who wish to become licensees of the California State Bar can do so in a way that really takes into account the changing landscape of access and provides the State Bar that flexibility to meet those challenges. So thank you to staff. I know this has been an incredible effort, especially General Counsel, Deftian, Bridget, to you and your team. Thank you so much. Ms. Ching, thank you. And looking forward to hearing how this progresses.
Yeah.
Thank you.
All right, next up is item 6.3. This is discussion of offer and compromise collection program update. And this is being presented by our Chief Financial Officer, RSLA Montoya-Chico. Welcome.
Hi, thank you. Okay, this item is for discussion. It's for discussion item only. It's a discussion item only. Right now, there's no board action required. So I'm going to go through what I'm calling the Offer and Compromise Collections Program. Let me turn this on quick. Okay, so I just want to give a little bit of background regarding our debt collections, which is what this program is aimed at. Just a little bit of background. So when an attorney is disciplined, they are required to reimburse the state bar for the cost of that investigation and discipline matters. Most of it is CSF debt that comes through, so a lot of the reimbursement actually goes back to the CSF fund for any reimbursements that we do collect. In terms of, here's some numbers that I wanted to kind of share. In terms of what we have, and this is only for disbarred and resigned attorneys, we have just over 2,400 disbarred and resigned attorneys that owe us almost $153 million. We've mentioned it in some of the previous agenda items. We don't tend to collect, in particular, the discipline cost model. We don't tend to collect a lot of our debt that is owed. As of 2020, we only collected almost $8 million. I think that's about 5% only of our total $503 million outstanding. So we really haven't collected much of the debt that's owed to us. And one important fact to note is 100 debtors comprise almost half of the total debt owed to us. So that means that these 100 debtors have average amounts that are in excess of $100,000, meaning their balances are well over $100,000 for just these 100 debtors that make up almost half of the amount that's owed to us. We do currently use the Franchise Tax Board. We have a contract with the Franchise Tax Board that is our main vehicle for debt collection, and they have two programs that we right now are participating in. One is the court order debt program, and the other one is the interagency intercept program, or the tax, we call it the tax intercept program. We recently got re-engaged in the tax intercept program since it was suspended during COVID, but we've been using the court order program the most. The way these two programs works is that they're either debts are collected either via wage garnishments or bank liens, or on the tax intercept side, they intercept tax refunds, any lottery winnings if there are any in unclaimed property. We have considered in the past in terms of our big, ballooning $153 million debt collection, debt balance that we have. We considered asking the board haven't done it, to consider asking the board to allow us to write off older uncollectible debt. We were thinking of anything older than 10 years. There's a lot of data also that's there that we need to kind of clean up a little bit. But instead of doing that, what we are proposing today, or just for discussion, I should say, is to have a one-time debt settlement initiative that I'm calling the Offer and Compromise Collections Program. We've discussed many times the general fund is facing significant financial challenges. So I think at this point in time, it would be more appropriate to engage in this one-time debt settlement program in hopes to get a lot of revenue in our doors quickly. Part of our research included seeing if there's other similar debt settlement programs that other state agencies, government agencies have done before, and there are. And here's just a summary of the three that are in the agenda item. The first one is the My Citation program, which related with infractions-related debt. And here I put just a couple of highlights of the successfulness of those programs that were ran. In the My Citation programs, as you can see here, they had about 61% of the debt reduced, paid in full, and they had a 52% reduction in average debt owed. Another program we looked into was the California Compromise of Arrears. This program was for a reduction of state owed child support. They had an average settlement of $16,000 per case, and they recovered $1.55 for every dollar that they spent implementing that particular program. And the last one we researched was the Judicial Council Amnesty Program. This one was a one-time program for delinquent bail and fines. They allowed 50% of their debt to be cleared, and they generated almost $15 million. So all of these were considered pretty successful debt settlement programs. So this is our program specifications for what we're calling the proposed state bar Offer and Compromise Collections Program. Here you can see the specifications, and it's meant to be a simple design. For the program to be designed rather simply. Obviously, the motivation is to try to incentivize debtors to want to settle and make their payment pretty easy, especially since we are working on ramping up our collections activity. So there's basically two key decisions that would be that the program would involve. One is an automatic reduction of any debtor who wants to reduce their debt for 50% of the original amount owed. That would be an automated process. They would go in, they would, based on their bar number, go in the system and say they want to settle for 50%, and it would essentially be an automated process. The second option is any debtor that requests for a reduction more than 50%. That would involve a more manual process where staff would be involved in deciding and asking for further support, supporting documentation, why that individual, that debtor, would want to settle for more than 50%. So this second point would require staff involvement, whereas the first one would not. This program or platform would be developed by a third-party vendor that we would engage, and we've estimated the cost to be between $600,000 and $700,000 to develop the platform. That would be, again, managed a lot in a self-service manner. On the opposite side, where we've estimated the revenue that could be generated is between $9 and $11 million. And there's obviously some assumptions that we had to make to derive this range. And that's that about 30 to 50% of our debtors would want to participate in this program, and that they would want to settle their debt for the range you see here of up to 50% of the amount owed. And I do want to highlight really quickly, this is probably a conservative estimate. This range is assuming, as I mentioned, there's 100 debtors that make almost 50% of our balances. They're probably not as likely as somebody with a lower debt balance to want to settle. If you have $100,000, even at 10%, that's still $10,000 that they may not want to settle. So we made the assumption to exclude those individuals from this range. If we did include them, making the same assumptions, we would generate 19 to 23 million if we did include those 100 debtors. So just for now, this is just an estimated, but obviously depending on how many debtors and their balances participate is going to be how much revenue we generate. And just overall, being able to implement a program, a debt settlement program like this, it does align with the board policy of right-sizing and making more fair the discipline cost structure. As we've mentioned, we have significant financial challenges in the general fund. So obviously doing this program would allow us to have a one-time quick revenue inflow into the general fund. We just discussed earlier in the meeting the discipline cost model, the revised discipline cost model. So that new discipline cost model revision will help reduce what attorneys will owe in the future so that we wouldn't have this ballooning collections. And finally, one key point to note is in order to implement this program, we do have to have statutory amendments and new rules. Some of these Donna just discussed in her prior presentation. They wouldn't be effective until 2025. So this program would, if the board was interested in allowing staff to develop it, it wouldn't be effective until sometime in 2025. That's what I have for my presentation. It is a discussion item, so any questions, comments?
And let me clarify the posture. It's discussion, again, to see if the board has any other request of us to further flesh out the design or cost, with the idea being that we would come back in September for approval to launch the program, understanding that it is dependent on some of these statutory changes we've been talking about being implemented.
Great. Any questions, comments? Yes, Trustee Good.
Not a comment, really, just a thank you to you all and to the executive director for coming up with this super creative idea that hopefully is going to bear some fruit for us in the future. So thanks so much. Appreciate it.
Leaving no stone unturned. All right. Yes, Trustee Tony.
I like this proposal a great deal. I have some questions. So, of this 152 million, okay, I thought I heard something about liens on property. How much of this 152 million is in liens, has been liened on some property?
So this is the 153 million is what they owe. The way we collect money, we send files, the debtors' information to the franchise tax board. They're the ones in charge of doing all of the wage garnishments and bank liens. I don't have the data broken out into how it's really a matter of what the franchise tax board can get from the debtors that gets remitted to us.
Okay.
That's a little different than the judgments and the property liens. I think the total amount owed is the total amount owed. I just asked Louisa to pull up our closed session item from May, not to post it, but just to share with me, because I think we did include some more of those stats in that item. I'm having trouble with the new system myself, and I can't figure out how to find it. So when I get it, I'll share that data.
Okay.
Yeah.
Here's where I'm trying to go on this. I think there are a number of things. I think in addition to this, what are we calling it? What is it called again? Your program.
The offer and compromise
Thanks.
collection.
The offer and compromise. I think we call that a carrot, right? I think there needs to be a stick too. And because this is money that's owed, this is debt. And, if I thought I could wait 10 years for debt to go away, I think that a lot of people would be willing to wait 10 years to get debt to expire. So, this is the type of thing where I could imagine that, there are like different things, like there are notices in the paper that have to be published when there's, you know when estates get settled? And you have to say, if you have any debt against this estate, you have to file it now? Do you know what probate, I think they call it? Do we do that? Yes, no?
I don't think we file any notices in the paper. What we do is we file judgments and liens against property, but I don't think, we don't do any public noticing as far as I'm aware. And
I'm asking
yeah.
a different question, which is, as part of probate,
Oh,
they're settling someone's account because they've passed away.
mm-hmm.
And they put in a little notice in the paper, and part of the probate process is they're trying to ask everybody, if you have a claim against this estate, please file it. I'm just asking if that's something I mean, if we're going 10, 20 years, maybe some of the people who owe debt may have passed away. I'm just thinking of life cycles.
Yeah, I don't know. Do you know, Aline? I'm not sure what we do in that regard.
No, I don't believe we do, but we can certainly look into, how we check against the states. So I'll talk to my team about that.
Okay, it's just something, I'm trying to be thoughtful about collection, and that there are a lot of different ways that collection happen commonly. That's a common form of collection. It's not frowned upon. It's part of the process of probate.
I do believe, Mark, that the Franchise Tax Board, because we have received money when a debtor has passed away and their estate settles, we have
Maybe they
received
do
money
it.
from that.
Okay.
So I think the FTB does. but-
Okay, good. I'm just asking because I don't know any better.
Sure.
But that would be a good thing. So these debts were incurred when attorneys were in the discipline system. Is that, I'm getting the understanding for the most part?
For the most part, yeah.
Okay. So one thing I would like to see is for this offer to be made, but also, we had an earlier discussion about expungement. I don't think we ought to be expunging someone's record unless their debt is clear one way or the other. I don't know, just to me, I think it kind of makes sense. We want to give incentives for people to pay the debt. And I'm okay with making an agreement and, negotiating something lower, but I can't imagine why we would want to expunge someone's record so in the implementation, because, like any board, we'll pass a rule or, a resolution, but staff is responsible for implementing it. I sure would like staff to first look for all the expungements before you do it automatically after 8 years, to simply say, do they have a debt? And if they do, then you're like, we're willing to expunge your record after the 8 years, but we got to reach an agreement because you're getting a clean start. We need a clean start too, as an agency, okay? We want the finances to be cleared too, not just the claims against you. So you said discussion. This is the things I think about when I look at this.
And really quick, the 153 million that I mentioned, that's only disbarred and resigned attorneys. There's other debt that's owed by active attorneys, but the 150 million is only for disbarred and resigned.
And of that amount, 10.8 million has been entered as judgments. So I just pinged Steve Moad. I should do Mia as well to say we should take what you've said as a public comment, because the expungement item just went out for public comment today, and make sure when it comes back that we incorporate that in the item, because I think that's a great idea. It's a great way to incentivize paying off what you owe.
All right, any other questions or comments?
I just want to add, obviously, or maybe not obviously, but we do collect a lot of debt in our office, and a lot of what you're talking about, I think, is very, very on point and a good thing to do. Generally, these types of opportunities are typically some forms of what people think of as amnesty programs. The thing about amnesty programs, I think they're often used when an organization maybe is facing what we're facing, some antiquated procedures, antiquated systems, a buildup of uncollected debt that's just going to be too difficult and really not possible to collect in its entirety because the regular timely process wasn't there. So I do think that looking at an amnesty program like this is the right thing to do. I do want to say, though, that I believe the common practice is they're more one-offs. We certainly don't want to give anybody the impression they should hang out there and wait for the next amnesty program. Our goal is to get a lot of this off the books, get the matters settled where it makes sense to do that, but then put better systems in place and be much more current on our debt collections and not create a future buildup of a lot of debt, outstanding debt. Certainly, I think it might make sense, and I think you were looking at this, to categorize the debt a bit. Certainly, things that probably will be easily collectible through the Franchise Tax Board are not things we want to put in the amnesty program. Things that are older, probably not as accessible through that process would be things that would make sense to put a 50% off amnesty or something like that on the table for. I think it makes a lot of sense, and I think we should definitely move forward with it.
Great.
Yes, Trustee Sewell.
I'm also in favor of the offer and compromise proposal that you put forward, Araceli. I just have just wonder whether or not, are there any ongoing costs associated with this, or there to administer and its implementation?
The main cost that we're going to incur is going to be the creation of the platform. And it is meant to be a one-time program, so we wouldn't have ongoing costs on the platform. Our current employees that are involved in managing the collections programs are the ones who would be doing any manual involvement. There wouldn't be any additional consultants hired to do the manual portion, if you will, of the program. I think other than the platform itself, which should be a one-time cost, there wouldn't be any other ongoing costs other than whatever we are already paying our staff that are currently working on collections as it is.
All right, looking over at the screen for our remote attendees, seeing no hands, looking around the room, seeing no hands. Thank you so much for your update and for your work on this.
You're welcome.
Thank you.
All right, item 6.4 is the approval of interest on lawyers' trust accounts grant distribution for 2025. And this item is being presented by Program Director Nguyen, and hopefully she is here and is being promoted.
I am.
Good afternoon.
Good afternoon. And Louisa, would you mind promoting Heidi too? She's going to be presenting with me. Good afternoon, trustee members. Hello, Leah. So Heidi, who's joining with me right now, she oversees our fiscal and compliance team. So we're here to answer any questions you may have. And as you all know, our office staffs the Legal Services Trust Fund Commission, and the commission is charged with overseeing the distribution of a number of grant programs that help support over 100 legal aid organizations throughout the state of California. And we're here today with item 6.4 to ask the board to approve an IOLTA 2025 grant distribution of $252 million, and then to maintain a reserve of $25 million. This distribution would represent a 264% increase over the distribution this year in 2024 of $95 million. So it's a very significant increase in funding for legal aid. And before I turn it over to Heidi, I do want to underscore that this dramatic increase this year is coming at a time where it's very needed within the legal services community. Legal aid funding right now is very volatile. And I think you heard from a couple public members today, some of our grantee organizations. There have been cuts at the federal level, at the state level, at the local level. The coronavirus recovery relief money is drying out. Foundation funding is also really volatile. It's an election year, so a lot of the foundation funding, that their initiatives are pivoting away from legal services and towards kind of other initiatives. So while the state bar funding is really a bright spot in terms of the funding landscape, it is coming at a time that is really greatly needed amongst programs, and it will help cover budget shortfalls, layoffs, and will help to kind of maintain much needed legal services to low-income and vulnerable clients. And then I also wanted to make note that the Trust Fund Commission, the last few months, they've been working on passing, and they just passed a 5-year strategic plan. And they embarked on this. One of the reasons is they've been receiving a lot of extra funds, other revenue streams. IOLTA has been exploding the last few years, so they really wanted to be strategic in how they are distributing this money. They wanted to come up with programs and initiatives alongside kind of the grant making program that will support the work of our grantees. So I will be sharing that strategic plan with you shortly. Okay, with that, I will hand it over to Heidi to kind of walk you through big picture of all the revenue streams that go into IOLTA.
Good afternoon, everyone. It's my pleasure to tell you a little bit about what makes up this $252 million distribution that the Legal Service Trust Fund has recommended. The revenue from the that is included in this really comes from primarily 3 streams. First, it's the interest on lawyer trust accounts that are held throughout the state of California. So we are estimating right now with actuals plus what we project through the end of 2024, we estimate that revenue to be $169 million. The second portion of funding that supports this distribution comes from net revenue that's available at the end of 2023. And so that's the surplus of funds that rolls forward into the next year for the distribution. So at the end of 2023, there was $193 million surplus or net revenue that rolled forward, in large part to lower the projections and interest revenue in prior years. In particular, in 2023 alone, we had a $73 million increase in actual interest revenue than originally projected. So that's a snowball that rolls over into the next years. And then the last piece of the revenue that makes this up is we, as Dawn mentioned, we have put $25 million into a reserve account, and based on the very favorable interest rates, we are estimating about $5 million in interest revenue from that reserve, which will roll into the distribution amount, as well as justice gap funds that are made through the attorney fee statement and online donations, which we project to be about $8.5 million in 2024. So from those total revenue sources, then the following deductions are made. The 2024 grant distribution, which was $95 million. The 2024 administrative costs related to the IOLTA program, which is about $3.9 million. And then the $25 million that we're holding in reserve. So that leaves us with a the recommended $252 million distribution for 2025. And with that, I would welcome any questions.
All right, thank you. Any questions for staff? Yes, Trustee Huser.
Was this amount kind of built up over time, or was this just because of the favorable interest rates currently, it was within the last year?
This is really driven by, by the interest rates over the last couple of years that have been that have continued to skyrocket and go. So we've had tremendous revenue at in the interest rates, and then the projections that we had made for what those interest revenues were conservative, and so it's the combination of those two factors that gives us that large surplus going over. And then, $169 million in interest revenue is just unheard of on its surface. So there's a combination of those two factors that lead us to this very sort of what we feel like might be a one-time sort of like mass distribution of funds.
Trustee Good, did I see your hand? Okay. Yes, Trustee Tony.
Out of curiosity, so I'm looking at these numbers, and in 2024, the 25 million reserve was equivalent to 26% of what was given out, the 95 million, 95.3 million. The proposal is to retain the reserve at 25 million, which is less than 10% of what's being distributed. If you were to keep the same proportion that you had in 2024, which is 25%, you'd have a reserve of about 66 million. And I'm just interested in what the thinking was, because it's often common to increase a reserve, like when you're doing budgeting, that when your budget increases, you still want your 3-month reserve, so you increase the amount of your reserve, but there was a choice not to do it this time, or in this case, and I'm just curious what the thinking was.
Sure.
So-
I can take this one, Heidi. So the commission did contemplate, because the commission passed a reserve policy that does allow it to go up to $40 million and then plus, right? So they chose to do 25 million. They actually had contemplated maybe 30 million, maybe 40 million, maybe a little bit more than that. But the main reason is political consideration. There are lots of funding cuts right now at the state level. So to have $40 million to sit in the bank account and not be distributed might send a message that some of our other state funding, our equal access funding, comes from the state, that is not as necessary. The other consideration in New York, there was a large amount of IOLTA money that was sitting in the bank, upwards of, I think, $100 million. The legislature did come in. Our situation is not the same, and sweep that money. So the short answer is a political consideration, so that, and you know, if there is a great need, and we did go on survey programs and talk to programs, and there is a need in the community. So given the political consideration and the need in the community, the commission decided 25 million to kind of help with the shortfall, because we know at some point in the next couple of years, interest rates are going to go down. And so again, like Heidi said, this is probably a 1-year thing. Maybe next year will still be high, but probably not at this record-breaking amount. And so that 25 million will help buffer once we start going down.
And if I could just add one other point of context about that, when we did come up with that original number of $25 million, it was based on, you know, a 10-year average of grant distribution amount. So we have not normally been in grant distribution sizes of $95 million or 200, you know, so in the past, you know, the $25 million was much more in keeping with sort of the normal distribution amount. And so that's there was a formula that was used to come up with that $25 million originally.
All right.
And I just want to share that normally this item would go on consent, put it on discussion because of the size and this significant year-over-year increase, because several of you have commented on kind of the cognitive disconnect of these massive numbers on our grant side, and yet what we really have available to us as an organization to operate. So I just thought, when I read the item and saw 150-something% increase, I just thought it was worth kind of highlighting that situation for the board.
Does this also mean that the amount that's actually sitting in those accounts is also just sort of has grown? I mean, not just the interest, but the amount that is sitting there in reserve that the clients have set aside is also growing quite a bit.
Well, we have some visibility into that now through CTAP. And so I don't, we've only been doing this for 2 years. So, and I don't think we had an increase in the base IOLTA balance. I think it was.
I can actually speak to this, Leah, if you, we do have that information that we track through our IOLTA portal, because we do get monthly, we get reports from the banks that hold IOLTA trust accounts. So over the last 2 to 3 years, I would say that the IOLTA account balances have gone from $5.5 million to the current balance now about $7 billion. So there has been some increase in the account balances, which based on our conversations with our national partners is unusual. California stands out of that, and a lot of the other states, they've seen decreases in their IOLTA trust account balances, but ours have been holding pretty steady and over the last couple of years have actually increased.
But I would just add that that small increase you talk about has credited for some of the additional funds we're looking at today, but the overwhelming majority is from the increase in the interest rates. For the longest time, interest rates were well below 1%. They were approaching zero, essentially. So that $5 million was earning very, very little. And now to have interest rates go up to 5% or more, that's a 500% increase almost, or 300 or 400% increase. And that's going to deliver that growth. But that also means that when interest rates go down, that growth will somewhat disappear.
All right. Any other questions or comments? All right, seeing none. If we could put the resolution up. Oh, I'm sorry. Yes, Trustee Barahona.
Just a quick comment, just to say thank you so much for your work on this. It's really critical that nonprofit legal aid organizations in California are supported and invested in. And I'm just glad that we're here taking this vote today, but just thank you so much for your work on this.
Thank you for that.
Amen to that. All right. We have the resolution up on the screen here. And unless there's any other, there we go. We'll supersize it. Okay. After trustees have had a chance to review the agenda item, may I have a first and a second?
Move to approve, Stevens.
I'll second.
Okay, first by Trustee Stevens, second by Trustee Good. Unless there's any further discussion, may I have a roll call vote?
Okay, 1 second. Let me pull this down. Barahona,
Aye.
Buenaventura,
Aye.
Chen,
Aye.
Narrows,
Aye.
Good,
Aye.
Grande, Huser, Shelby, not present. Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo, not present. Stallings,
Aye.
it's 11 ayes, 0 nays, motion carries.
All right. Duan and Heidi, thank you so much for your care in this area. I think it is absolutely one of the highlights that the State Bar can really put to the forefront as to the good that can be accomplished through this program. Appreciate the trust that our various stakeholders have in the State Bar to allow us to administer these very much needed funds. So thank you for your vigilance. Thank you to the Legal Service Trust Fund Commission and the vision that they have, and to all the frontline workers who are working in legal aid, thank you for your dedication. So we're happy to partner with you.
Thank you.
Thank you.
All right, this brings us to item 6.5, and I anticipate that this will be the last agenda item of today's meeting. So with that exhortation, this is approval of revisions to Appendix A, schedule of charges and deadlines related to law school fees. And we have Program Director Cody Hounanian and Principal Program Analyst Natalie Leonard. So welcome, and the floor is yours.
Thank you very much, Chair. And I'll keep my comments very brief because I think this issue has already been discussed deeply. But as a reminder, at the March 2024 meeting, the Board of Trustees approved revisions to fees related to the California Accredited Law Schools, or the CALS. And as just a quick reminder, those revisions included a few kind of main top lines. First, setting a fee structure that generates roughly $275,000 in revenue for 2024. Important for this discussion, renaming the periodic compliance report fee for CALS to the accreditation services fee, and similarly renaming the annual compliance report fee for unaccredited law schools to the registration services fee. Both of those intended to better reflect how that fee revenue is used here at the State Bar. The board also approved, related to the accreditation services fee, an approach in which that fee would be calculated based on enrollment numbers, and the final fee amount would be calculated, and there would be a reduced fee rate for those schools that have been recognized by the Committee of Bar Examiners as jointly accredited, recognizing that there's a reduction in the accreditation services required for those schools. And there were various other changes approved by the board in March 2024. I'll skip over those, but the board already considered and approved those. At the time, at the March 2024 meeting, the specific amount for that accreditation services fee was not adopted. Staff let the board know that additional time was needed to work with law schools to finalize the methodology for calculating enrollment at law schools, and that enrollment figure is necessary for coming up with this fee. So at the direction of the board, staff met with all of the impacted law schools, each of the CALs, and based on those discussions and the feedback received, staff finalized a methodology and approach where the accreditation services fee, the enrollment figure that would be used in the calculation would be defined as the unduplicated count of all students who were enrolled at a law school in a JD program at any point in the designated 52-week period. And we would exclude any of those students who received a full refund for the entire period, recognizing that those students likely didn't attend. So after speaking and meeting with all of the CALs and developing this methodology, this approach, we recognize that nearly all of those CALs already use this approach for enrollment counts, and the few that didn't only needed small adjustments to align. So now that the methodology has been finalized, we are returning to the board today with the fee amount for the 2024 accreditation services fee. For the CALs that are solely accredited by the Committee of Bar Examiners, that fee amount is $60.44 per enrolled student. And for those recognized as jointly accredited, that adjusted down fee rate is $53.79 per enrolled student. So the board is asked today to approve that fee amount for the accreditation services fee, as well as other revisions to the Appendix A schedule of charges and deadlines that reflect the various other changes that the board approved at the March 2024 board meeting. And all of those changes are reflected in Attachment A and Attachment B in red line as part of the staff report.
All right. Fantastic. Thank you for that presentation. I will turn it over to the trustees to see if there's any questions. Any comments? If no questions or comments, may I have a motion? Well, strike that. We'll review the resolution first. All right, once trustees have had a chance to review this resolution, if I could have a first and a second.
I'll move it.
First by trustee Sewell. Is there a second?
Second.
Okay. Was that trustee Buenaventura?
Yes.
Okay. Second by trustee Bonaventura. Unless there's any further discussion, may I have a roll call vote?
Barahona,
Aye.
Buenaventura,
Aye.
yeah. Chen,
Aye.
Cisneros,
Aye.
Good,
Aye.
Grande. Aye. Huser. Shelby, not present. Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo, not present. Stallings.
Aye.
11 ayes, 0 nays, motion carries.
All right. Thank you, Cody and your team, and for just getting together with all of the law schools. I mean, that's a very large task in and of itself, and so to reach some consensus in this very heated topic, I think at times really reflects well on you and your team. So thank you, and thank you to all involved in this.
Thank you for that.
All right, that is the final item that we will take up today. I know everybody wants to talk about AI at 4:45, but we will say that for when we're a little bit fresher tomorrow morning. So we will adjourn for today, and we'll see everybody back here at 9 o'clock.